Thank you, Judge. I will let the attorneys in start the recording. Shall I do we can start? Judge, may I open court?
Please. Thank you, Ann.
Thank you, Judge. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-5160, Charles K. Hudson versus David Longly Bernhardt, in his official capacity as Secretary of the Interior et al. Appellants. Ms. Huron for the appellants, Mr. Sullivan for the appellee.
Good morning, counsel. Ms. Heron, please proceed when you're ready.
Thank you, Your Honor. May it please the court, my name is Rachel Heron on behalf of the federal government. With the court's permission, I'd like to reserve about 2 minutes of time for rebuttal.
Sure.
The plaintiff in this case, an individual member of the 3 affiliated tribes of the Fort Berthold Reservation, seeks to overturn the results of a 2013 election administered by the Department of the Interior based on readings of tribal law and federal law that have been rejected by the tribe and the agency, respectively. Government's briefs explain why plaintiff's arguments fail on the merits, but I'd like to start today by addressing the threshold question that was identified in this court's recent order, which is whether plaintiff has Article 3 standing to raise his arguments that Interior allegedly violated tribal and federal law in the first place. Upon consideration of that issue, the government believes that the plaintiff has not, to this point in the litigation, met his burden of demonstrating a particularized injury. To the extent this court is willing to give plaintiff the opportunity to demonstrate an injury now, plaintiff's burden, in the government's view, would be to demonstrate that he is personally impacted by the tribal constitutional amendments that became effective as a result of the alleged misapplication of tribal and federal law. The government would note that plaintiff has not made any such arguments up to this point in the case, neither in his submissions to the agency nor in his briefs to the court. Your Honors, I'm happy to elaborate further on the government's view of the standing issues here, unless there are specific questions on standing that the court would like to hear the government answer first.
There's a regulation by Interior that allows individual members to challenge votes. And so allowed certainly at least at the administrative level this type of challenge. I don't think there's any dispute about that. My question is, what is the origin of that regulation? I didn't see anything sort of in the Indian Reorganization Act that would have been, that was drawing upon or purporting to interpret. And so what I was trying to, and thinking about standing here, was understand what the basis was for Interior in recognizing that right, or maybe creating that right. You can tell me which in that regulation. Is there something about the historic trust relationship, historic practice with tribes that allows these type of challenges in a way that seems different from elections?
Yeah, so Your Honor, the regulation in question, you're correct, allows any member who has voted to challenge. I will say that in practice, the IBIA, which is the body within Interior that hears the appeals within the agency from these challenges, does apply standing principles as a matter of what they call administrative prudence. And there are IBA decisions I can point Your Honors to that make that point. So it's not as though that there is sort of no concept whatsoever of standing in these administrative challenges, although we acknowledge that the IBIA here did not make any findings with regard to Mr. Hudson's standing. In terms of the origin of the regulation, I think that I view this regulation as Section 5123A1 of the statute gives the Secretary the authority to promulgate rules and regulations which will govern the conduct of these secretarial elections. And this mechanism for voters bringing a challenge is simply one regulation that Interior has promulgated. I am not aware of any view by Interior that this is sort of a necessary feature as a result of the trust relationship, or something like that. And
when the IBIA has applied standing to these voter challenges, what types of voter challenges have met that standing threshold?
So, Your Honor, I don't have,
but just an example.
Yeah. So I think the one example that I have here today for the court is one in which they found that there was not standing. So I can't, standing here today, give you an example of a time where the IBA has made an affirmative finding that there was standing to proceed. But I think that the analysis would proceed similarly to sort of what the government is saying here would apply in the Article 3 context in the federal courts, in that you would need to show some personalized impact from the decision, in this case, the approval and making effective of these constitutional changes. It would not be enough simply to have an interest in making sure that the agency is applying law correctly, or correctly in the challenger's view, standing alone, no matter how sincerely held that belief is, as the Supreme Court has affirmed just this term in the Carney v. Adams decision.
Can you just give us an example of what would be enough?
Sure. So I think
in this case, I mean, on the facts of this case.
So, sure. So I think one of the difficulties here is that it's not immediately obvious from the amendments that are in question, which have to do with the composition of the Tribal Business Council, how this particular plaintiff would be able to show a particularized injury. But I think that you could posit, for example, with regard to the First Amendment that went into effect as a result of the 2013 election, which increases the size of the Tribal Business Council. Potentially, you could imagine a sitting member of that council whose vote would be diluted by the inclusion of new members on that council and the expansion of the body, being able to show that they are injured in a particular way. And also, you could imagine different kinds of amendments that would have a clear impact on just a non-governing member of the tribe, for example, something that went to membership criteria, something that changed the ability or the eligibility of voters to vote in future elections. In those kinds of situations, I think a plaintiff would be able to readily show that they are personally impacted, and there's been no showing of that here. And as I said, it's far from clear to the government how the plaintiff would be able to make such a showing in this case, given the nature of the amendments. And on that point, I would add as well that in thinking about whether the plaintiff can show a personalized impact from these amendments, it's also important to keep in mind that in large measure, the 2013 amendments, and particularly the First Amendment that was approved in 2013, was actually rolled back by a 2016 secretarial election that plaintiff separately challenges in another lawsuit that's currently being held in abeyance. There are, I think, a number of hurdles to the plaintiff being able to show a particularized impact here.
Is it true that the 2013 changes never actually took effect? That's what Mr. Hudson said in opposing remand, and so that the council never really implemented the change, at least the expansion, say, in the number of members of the business council. And I don't know if there were any anybody involved in felonies that would have come up at all. Hopefully not. And then it was, as you said, sort of undone in 2016. So I'm trying to figure out whether there was ever any on the ground practical implementation of the 2013 provision that he challenges that you're aware of.
Your Honor, I'm not aware of that. The record obviously that we have before us only goes to the state of things after 2013. I'm not aware of what happened in terms of the tribe's actual implementation after 2013, other than, to note that there was a relatively short period of time in which these changes could have even come about before we had this 2016 election that changed the legal state of play again.
I'm sorry, just clarify one more thing. The 2013 election authorized an increase in the size of the business council, but that election didn't actually increase the size of the business council. Was that supposed to happen at like the next election?
I think the text of the amendment, which is at JA 234, sort of spells out what the sequence would be in terms of when the elections would be held to add these new members. But as far as I'm aware, it's not like there was sort of a slate in place when the 2013 amendment was.
And those other elections were not held to increase.
That's my understanding, Your Honor. I see I'm running out of time, so I would simply note on the merits that the government, to the extent this court reaches the merits, stands by the arguments that it makes in its brief on those issues, and to the extent this court has any questions on them now or in any rebuttal time that may remain, I'm happy to answer them. Otherwise, the government would ask the court to vacate the decision below.
Okay, thank you. Ms. Herron, we'll hear from Appellee now. Mr. Sullivan.
Thank you. May it please the court, my name is Patrick Sullivan, representing Appellee Charles Hudson. We ask that this court affirm the district court and hold that Interior's misinterpretation of the IRA and Article 10 by erasing the tribal quorum is arbitrary, capricious, and contrary to the statute. But I do want to address the issues as well. That from your order, this court does have Article 3 standing. I'm surprised to hear that we're focused on the particularized prong, but I am glad to. First of all, the clearest signal that this is a particularized injury is that the regulation that Judge Millett referred to, which narrows the people who can actually challenge that election to not just any voter, but down to those who, not to any member, but any qualified voter. And then again, Mr. Hudson actually did vote in that election. And I think the standard that the Department of Justice is putting forward is that somehow what we need to do is look at whether Mr. Hudson's, whether the outcome affected him and injured him, which really is counterintuitive. I mean, I think you expand that logic, you would think that not getting your choice of presidential candidate would be seen as some kind of particularized injury. It requires going into Mr. Hudson's brain and examining his personal policy preference.
What is his injury? What is the injury on which you base your claim of Article 3 standing?
It's the diminishment of his vote. So, but for Interior's practice, this amendment wouldn't have happened because, and that's a personal injury. If you look at Gill versus Whitford, that what's happened is that his vote now carries less weight.
So a vote dilution theory.
Yeah, it's diluted or it's diminished relative to the outcome that he votes in.
I mean, it would seem that he has not a vote dilution injury, but a vote concentration benefit. They're making a quorum requirement too strict in your view, the effect of which is to give the people who vote a greater vote. How's that an injury?
No, I understand, but the violation of the statute is not a benefit to him. But when you vote, you can vote in the negative or in the positive. Here, Mr. Hudson opposed the amendment. And so what happened then is the Interior's practice denies him the benefit of non-votes being counted as no votes toward the quorum. And so it makes his preferred outcome less likely vis-a-vis his one vote when he votes. In your example, when he supports an amendment, that amendment is indeed more likely to pass, but then his voting power is diminished in another way because that amendment is then vulnerable to a subsequent, later, unlawful secretarial election conducted by Interior without the requisite solemnity and formality.
I'm sorry, what's the causal connection between the fight here over how the quorum requirement works and the fact that his position in the election didn't prevail. Those would seem to be just different issues.
Well, they're tied by the fact that if Interior respected the quorum that's in Article 10 in an IRA, there would have been a different outcome. So you don't have to look at the injury to Mr. Hudson, and because that, by the way, that would put the court in an untenable position of evaluating which injuries, which personal injuries in terms of political outcomes of various types of elections are justiciable. I wouldn't ask this court to do that because that would be a very sticky situation for the court to delve into. But here, the injury is really to his vote, and the practice. When we talk about positive and negative votes, those things add up to the fact that it puts my client on a day-to-day basis in a defensive position, because the Constitution provides for things like his enrollment status. He could be disenrolled. It provides for his rights vis-a-vis his allotted lands. He's a landowner on the reservation.
Can I just ask this question? If suppose he didn't vote, but he opposed the measure, then it seems like someone in that position could say the same thing, because they could say that, well, I wish the what you believe to be the proper quorum requirement was enforced, because if it had been, then the measure wouldn't have been adopted, and I don't like that. I don't like the outcome that exists now because the measure was treated as having been adopted. And it seems like the fact of voting then doesn't really matter that much, because the vote, as Judge Katsas pointed out, was counted and was maximized. But the injury is just the asserted injury is disaggregated from it, because that would be the same for somebody who didn't vote at all. And I think it's pretty clear that if somebody didn't vote at all, they can't claim an injury in this context.
Well, I understand your hypothetical in which my client didn't vote, and I did mention that there is an injury as I spoke, even to those who don't vote, but that's not what we're asserting here. What we're asserting here is that when Mr. Hudson did vote, the outcome changed based on Interior's practice. But it wouldn't have even had to have changed to have diminished his vote. I mean, if you look at Gill versus Woodford, Baker v. Carr, in those cases, the courts didn't delve into whether they wanted a Democrat or a Republican winner, or what those policies, Democratic policies or Republican policies, would have affected those voters. That would be an impossible position to put the court in. And so that's why we...
in those cases, the change in the vote was vis-a-vis other voters. Your vote has less power than other voters. It's not about your ability to obtain particular desired outcomes, or preserve them. And so what I'm trying to understand under this, we have to ask not generically about this election process, but this 2013 election, because that's the one that's challenged. And so in voting in the 2013 constitutional amendment election, was his vote any more or less potent, I guess, than other voters?
Yes, Your Honor. His vote was less potent than those who voted in favor of that amendment. So it's not another class of voter, but in terms of he was disadvantaged in terms of his vote because he happened to vote against that amendment. So that's where I'm going. And I think and it's true that I mean his preference would have been, and the reason that he expressed to me that he voted against 2013 is that it didn't expand tribal off-reservation voting rights. He has a separate particular...
I understand that, but the 2013 changes that he voted against never took effect, right? You told the district court in your opposition to remand that they never had been implemented. So how was he injured? His vote, he cast a vote just like everyone else. It was counted just like everyone else's. It carried the same weight as anyone else's, pro or con, that actually voted in that election.
I mean,
and the things he complained that he opposed, you said it's because he opposed it. But the things he opposed never took effect. So I'm just trying to understand, because that's what we're deciding here is this 2013 election.
Well, to be fair, they never took effect because of Mr. Hudson's lawsuit. They would have taken effect if he hadn't sued, brought his original case, way back then.
That's got nothing to do with the standing question that I'm asking you. All right, and that is, how was he injured by, you say he voted against something that never took effect,
right.
And his vote, I think, vis-a-vis other voters was the same, just you vote pro or con.
Right. Well, his vote was diminished versus those pros. But let me go. I think the Gill and Baker cases really show that I think this court may be looking further than it needs to in terms of the injury, because what we're looking for is just a plain, direct, and adequate interest in maintaining the effectiveness of one's vote. That's the interest recognized in Baker v. Carr. But I also want to point the court at a couple other cases. For example, in Carlson v. Postal Reg Commission, the plaintiff there established standing based on the difference in the price of a postage stamp. So consider whether that's more or less of a particularized and concrete injury than what we have here. You can also look at the sweeping district court rulings in Harjo v. Kleppe, which provide that in which the plaintiffs challenged essentially the government-to-government relationship between the United States and their Indian tribe. So if the court assumed standing there, which it did, then I argue that my client should also be able to establish standing here. I see I'm out of time.
Let me make sure my colleagues don't have further questions. Okay. Thank you, Mr. Sullivan. Ms. Herron, we'll give you 2 minutes for rebuttal.
Thank you, Your Honor. So I would just touch very quickly on this issue of whether there's a voter dilution injury that can be shown here. And in the government's view, this is not a voter dilution case. Voter dilution is an injury that generally comes up in a situation, as the panel has noted, where an individual's vote, the power of that vote, is being distorted as compared to other voters. Here, I think the right way to conceptualize the way these secretarial elections work is that there are 2 separate hurdles that a proposed amendment needs to clear. And one is that it needs to get the majority of votes cast. And in that context is where you could potentially be concerned about some sort of a dilution argument, to the extent the way that the votes are cast amplifies the power of certain voters over other voters. But then there is this separate hurdle that needs to be cleared, and that hurdle is the meeting of the quorum requirement. And that quorum requirement applies uniformly, as Chief Judge Srinivasan noted. The effect that it has is felt alike by voters and non-voters alike. And I think that separate issue just is distinct from the way that votes are weighed in the majority vote context, which is where you could potentially see a voter dilution claim. The only other point that I would note is that on this issue of the fact that plaintiff filed an administrative petition, Massachusetts v. EPA, among other cases, show very clearly that the fact that there is a particular right to bring an administrative petition does not mean that the plaintiff does not then need to show an Article III injury in order to challenge a denial of that petition in the federal courts. For these reasons, the government would ask that this court vacate the decision below, whether for lack of standing or if it reaches the merits for the reasons stated in the government's brief.
Okay. Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 20-1132, Food and Water Watch and Berkshire Environmental Action Team petitioners versus Federal Energy Regulatory Commission. Mr. Carlesco for the petitioners, Ms. Chu for the respondent, Mr. O'Neill for the interveners.
Morning, counsel. Mr. Carlesco, please proceed when you're ready.
Morning. May it please the court, Adam Carlesco, Petitioners, Food and Water Watch and Berkshire Environmental Action Team. I'd like to reserve 3 minutes for rebuttal. This case involves the Federal Energy Regulatory Commission's failure to review the full scope of environmental impacts of the near doubling of gas capacity through the now primary delivery point for the Springfield, Massachusetts local distribution grid. The project involves installation of a new compressor station that is significantly larger than its predecessors at a critical juncture point between one of the largest interstate transmission operators in the country and a local distributor of gas. This project was specifically designed to facilitate increase in residential and commercial burning of gas in the fourth largest city of New England. The Commission found that the large operating project would not have any significant impact and thus required no further environmental review, but it did so only because it ignored all reasonably foreseeable upstream, downstream impacts, the indirect effects on their depot, which would be induced production and combustion of gas. These effects have potentially significant impacts on Springfield's air quality, public health, public safety, and of course the global climate. And now the Commission asked this court to approve its dereliction of its statutory duty under NEPA and the Natural Gas Act by setting an impossibly high preservation standard that finds no support in the law of the Natural Gas Act or the circuit. This court should vacate the Commission's Certificate of Public Convenience and Necessity for 3 reasons. The Commission failed to take a required hard look at the reasonably foreseeable downstream impacts of increased combustion of gas facilitated by this project, despite having known upgrade capacity, known contracted volume, known purchaser, and known end use. Second, the Commission failed to evaluate the reasonably foreseeable upstream gas extraction effects of expanding transmission capacity. And third, the Commission failed to evaluate the significance of this project's emissions as required by NEPA, dismissively stating that every model available to it is fatally flawed because none is universally accepted. This is an impossible standard. So first, I would like to direct this court's attention to the downstream emissions. FERC refused to take NEPA's required hard look at reasonably foreseeable downstream gas combustion facilitated by this project. Commissioner Glick stated in his dissent at Joint Appendix 504 and 505 that because there was a known upgrade capacity, a known contracted volume, known purchaser, and known end use, and that 97% of gas use in the U.S. is through combustion, he noted that this makes a relatively easy case to determine that the downstream impacts were reasonably foreseeable. So FERC could have reasonably predicted downstream gas emissions, but chose not to. Under Friends of Capitol Crescent Trail, the Federal Transportation Administration, a 2007 D.C. Circuit case, this court found that NEPA requires calculation of downstream effects when a project's capacity and transported volumes are known, even if the precise destination or method is not necessary, despite the fact that we know that the destination is the Springfield local distribution grid and that consumption will be used through commercial and residential combustion. Second, the regulation 40 CFR 1508.8b states that indirect effects may include growth-inducing effects. Moreover, the Ninth Circuit's recognized that it's completely inadequate for the Commission to ignore growth-inducing effects where a project has a potential to spur demand. In this case, both Tennessee Gas and Columbia Gas within advertising material have recognized that the development of this infrastructure specifically to address future demand and potentially lift moratoriums of gas expansion within the Springfield distribution network. This is a reasonably foreseeable growth-inducing impact. Further, the Commission argues that the variability over the lifespan of this project would make this unforeseeable. However, this court has rejected this with the Sierra Club. They've tried Sierra Club v. FERC, which dealt with a small trail project. They found that they were a legally relevant cause of these emissions, where there was variability over the lifespan of 2 power plants that were burning gas, despite there being a variability in demand for that electricity coming from those power plants. And so we would note that the Commission also argues that they lack the authority to look at these downstream effects because they argue that they cannot deny a project due to upstream or downstream impacts. However, this court has squarely rejected that argument.
Question.
Yes.
On this upstream effect.
Yes.
One of your arguments was about sort of the glut in gas. the surplus in gas that is now out in the market. And I assume you made that argument at the time. So how do we know, even if there's increased demand, that it will increase production rather than use surplus?
So the standard here is that, and it's an argument we raised within our rehearing order, is that the Eighth Circuit's found that if the nature of an effect is reasonably foreseeable, which would be extracted use, extraction on the whole, but its extent is not, an agency can't simply ignore that effect. In this case, the Commission said that upstream impacts of extraction generally are fully unforeseeable, but moreover, this project allows for a 20-year contract agreement between Tennessee Gas and the distributor of this gas. Over the course of the lifespan of this project, the gas has to come from somewhere. And if you look at Joint Appendix 296 and 297, you'll see a map of Tennessee Gas Pipeline's assets that run from this project in Ogallala, Massachusetts, down through Connecticut directly into Marcellus and Utica shales, as well as another pipeline run by Tennessee Gas that runs through New York directly to the Marcellus and Utica shales. The standard here is
Does that mean that they would, does that mean that they would be sourcing the gas from those particular fields, or?
This is, Tennessee makes the argument
that this isn't a pipeline.
My apologies. So Tennessee makes the argument that it's unreasonable for them to predict where this gas might come from because they might be, over the course of the lifetime, 20 years, purchasing this from other different pipelines throughout the region. But in this case, all roads lead to Rome here. The Marcellus and Utica Shale is the principal development territory within the Northeast. Tennessee owns gas pipelines that run directly from it to this compressor station territory. And moreover, they make an argument that they might be getting gas from the Drockett, Massachusetts connection. If you look at the maps at 297, you'll also see that the pipeline that leads directly to Drockett, Massachusetts on the eastern side of the state comes from the Marcellus and Utica shales.
Do you have to show things with this level of particularity? I mean, I know the FERC said so you didn't identify, what new wells were going to be drilled. I'm just trying to ask, and I appreciate the answers you provided here, but does NEPA only kick in if you have that level of knowledge that it's going to cause a new well to be drilled, or it's going to come from here versus there, as opposed to the gas system generally is going to require some sort of incremental increase in the production of gas from wherever that increase may come, and it's that incremental increase in production of gas that NEPA should be analyzing.
From my understanding with NEPA, it doesn't require that sort of detail. The reason
it does require the detail, or
does not require that level of detail. The reason that the Commission used here for this being fully unforeseeable, despite just the nature of extraction being known, is that they say that if they don't know the specific source, like i.e. the specific well it's coming from, that it's not a reasonably foreseeable consequence. However, when they make this argument at Joint Appendix 389, they only cite themselves. They cite no relevant case law of this circuit whatsoever. And moreover, there are other tools that are available to other agencies in the federal government, such as the Bureau of Ocean Energy Management, the Bureau of Land Management. They're able to assess upstream impacts based upon supply and demand variance. And this was raised within NYU's amicus brief that page 11 and 12.
I know, but there's some question about whether you preserved rehearing an objection to using a particular test by FERC. So I'm just trying to get into a more general question of whether FERC asked the right question.
So we specifically did raise the foreseeability of upstream impacts, and that's really the issue here, is that the Natural Gas Act requires you to raise the arguments that you would be raising before this panel here. And however, the specificity of it is not necessary. This court said in Consolidated Edison Company of New York, which is a 2003 case, that it has to be brought clearly to the attention of the Commission. And that's exactly what happened here. The Commission addressed this ad nauseum and within their rehearing order at Joint Appendix 492. They noted that we raised upstream production issues. And the difference here between this case and Burkhead is that Burkhead made an argument that the record was fairly undeveloped, but they failed to raise that development issue within their rehearing order. We argue here that the nature of the upstream impact is known, even if the extent or particularities may not be, they still can't ignore that effect entirely.
Did you make the argument that they needed to gather more information?
We did not raise that argument for upstream impacts because they had a list of pipelines that would be coming from, and they had a number of maps that showed Tennessee gas pipelines, pipelines that they run into the region.
So you're talking about the analysis that should have been made on the existing record?
Yes. And so I'd like to turn what I view as one of the larger failings within the commission here, which is the assessment of significance. The Sierra Club v. FERC decision from 2017 stated clearly that NEPA requires agencies to include a discussion of the significance of greenhouse gas emissions. In this case, the commission has categorically excluded all consideration of greenhouse gas emissions. Not just in this case, but if this principle were applied, it would exclude consideration of greenhouse gas emissions across any agency decision because they argue that there is no universally accepted methodology. This is an impossible standard here, and they raised the standard significantly higher than they did in the Earth Reports case in 2016. There they argue that there's no standard methodology. Here they're raising the bar to something that no methodology within scientific literature could ever really meet. And in doing so, they reached the decision that this project would have no significant impacts because they categorically ignore those impacts on the whole. And we would argue, too, that there are tools that are available to it. The commission here has kind of put the cart before the horse and has instead argued that they need not look at this issue at all. And Commissioner Glick notes that, not Commissioner Glick, but by categorically excluding greenhouse gas significance on the project level, which is where FERC regulates the largest gas industry on the planet, at least on the transmission side, every single individual project's impact on climate change is functionally zero. And the Ninth Circuit has found that in the Center for Biological Diversity versus the National Highway and Transportation Safety Administration, that while there are a range of cost figures for greenhouse gas emissions, they are most certainly not zero. And the reason that the commission is able to reach its insignificance decision here in denying further environmental review is specifically because they completely mark all greenhouse gas emissions significance as zero, despite doing no significance evaluation whatsoever. And so in many respects, the commission is speaking out two sides of its mouth. It's saying that this is insignificant while also refusing to do any sort of significance assessment here. Additionally, I'd like to raise the issue of segmentation here. Under this court's precedent, Sierra Club versus Army Corps of Engineers, to show that segmentation has occurred, you have to demonstrate contemporaneous construction schedules, closely related utility, and interrelated nature. In this case, we meet all three. Both the 261 upgrade project compressor station on the west side of the Connecticut River and the Longmeadow metering station on the east side of the Connecticut River are built in tandem. The metering station was constructed first, and while a metering station can be installed without additional capacity, this was specifically designed to anticipate the additional capacity that is facilitated by this compressor station. And the compressor station and Longmeadow have overlapping construction schedules, and their utility here is to move additional gas capacity into the Springfield distribution grid. They are both supplied this gas under the same contract agreement between Tennessee Gas and Columbia Gas Distribution.
It's been found, though, that the Longmeadow project has independent role, independent utility that it's serving, and that it would go forward with or without the 261 upgrade. Yeah, that's at least a relevant consideration in the segmentation analysis, isn't it?
You could technically build a metering station without a compressor station, but when you're building it to anticipate the increased volume that's facilitated by a compressor station, the independent utility of it is de minimis. It will really just be, because a metering station is meant to measure the volume and flow that would be coming through it. If you aren't increasing the capacity of what is being pushed through it, then it doesn't need to be upgraded to meter that increased capacity. So they have similar utility here. They're meant to work in tandem. And as this court said in the Delaware Riverkeeper case, in that this is, what's the quote? they are meant to function together seamlessly, which is exactly what happens here. Moreover, both Tennessee Gas and Columbia advertise this as addressing interrelated challenges for needed additional capacity. With that, I see that my time is up unless you have further questions, Your Honor.
Okay, thank you, Mr. Carlesco. We'll hear from for counsel now, Ms. Chu.
Good morning, Your Honors. Savannah Chu for the Federal Energy Regulatory Commission. In this case, the Commission made a record-based, fact-specific determination that this particular reliability project, designed to address local reliability needs, would have minimal emissions and minimal environmental impacts. My colleagues' arguments are not tethered to the record in this case. Going to a question that Judge Millett asked about the standard that should be applied to whether upstream induced gas production could be reasonably foreseeable as a result of a particular pipeline project, the answer is the standard is not relevant in this particular case. Here, the Commission made a decision, it made a record-based decision that any induced production was not reasonably foreseeable because this particular project, which involves a 2-mile pipeline loop located adjacent to existing pipeline and upgrades to aging compressor station units, that this particular project is taking gas from other interstate pipelines. That's in the certificate order at paragraph 61 through 62, JA 389 to 90. And of course, we have to remember that as Chief Judge Srinivasan,
is it going to move more gas or the same gas?
Your Honor, I think first, the petitioners did not raise the specific issue, and on the record,
Not raise the record issue of what? I'm just asking a fact question. I thought the whole reason the court authorized this is that it's going to move more gas. Is that a disputed fact?
No. I mean, let me clarify.
Sorry, so the petitioner agrees that the point of this is to move more gas.
No, that's wrong, Your Honor.
Okay.
The record shows that actually the reason for this particular contract between Tennessee Gas and Columbia Gas, the local distribution company, is to enhance the reliability of the Columbia system. The project is designed to serve existing customers of Columbia Gas. And in fact, what they were doing was replacing their less reliable, interruptible service with firm transportation.
I thought either Columbia or Tennessee Gas or both, most of them had said that this was going to lead to increased provision of gas.
I don't believe so, Your Honor. I think that Columbia Gas actually participated as a party in the FERC proceeding and submitted some statements where they said that their existing interruptible service was not reliable and extremely costly, and they were trying to replace that interruptible service, the secondary capacity, with firm transmission capacity, which would enable them to meet winter heating demands in the New England region, which, as Your Honors are probably aware, is a serious issue in that region.
So JA 113, Columbia Gas says that the additional capacity will be used in large part to serve new customers, converting from oil heating to natural gas.
Your Honor, I believe this is a part of the Massachusetts BPU's order approving the contract between Tennessee and Columbia Gas. But later in that same order, or earlier in that same order, rather, they talk about the replacement capacity.
Well, they can do both. You can have replacement and you can increase. All I'm asking you is, this is on the record. Columbia Gas said this, and I thought you were disputing that there was going to be any increased amount of gas.
Your Honor, sorry, that was the Massachusetts BPU. Columbia Gas, I believe there were effectively two reasons. There was the replacement capacity primarily, but Columbia Gas also said that to the extent that new customers would be served, these new customers would be transitioning from oil heat to natural gas.
So that's more gas.
Possibly, but the record doesn't show what portion might be new customers. The record shows that the primary reason, the driving force for this contract was the replacement of secondary capacity. So I think if you look at the Columbia Gas statement itself is more clear because, Your Honor, the JA 113 site is the Massachusetts CPU order, which may have some statements that appear inconsistent, but it's the Columbia Gas statement that is more clear.
So did FERC find that there would be no increase in gas, the amount of gas moving through this pipeline? Did FERC make that fact finding? That's why it couldn't assess there were no upstream effects because there was going to be no change in the volume of gas produced as a result of this upgrade?
No, Your Honor, the commission did not have an opportunity to make that finding. Well, it didn't make the finding, and it wasn't raised on the hearing, so it didn't have an opportunity to more closely address its finding.
What I understood it to say was you can't tell us which wells will be drilled as a result of this. I did not understand it. And please correct me if there's a fact finding that I've missed where it says we don't think there's going to be any increase in volume of gas, and that's why we don't need to analyze upstream effects. Please tell me that. My understanding from the decision was that they said you haven't shown us which well will be dug as a result. New well will be dug as a result of this project.
Right, Your Honor. The commission did say that.
Okay, did it say the former? Did it say there's no upstream effect because there's not going to be any change in the volume of gas?
The commission did not say that there would be no change in volume, but it wasn't
Did the commission
the standard.
That there would be some change in volume? Some increase in volume?
There may be. I think there may be, but there's no finding as to whether or not there would be a change in volume as a result of this particular project.
Does the commission have to figure that out before it can, if it knows it has to analyze upstream effects, whether someone argues it a particular way or not, it knows it has to analyze upstream effects if it can. And so if it knows doesn't it need to first figure out if there's going to be any increase in gas?
Well, Your Honor, the commission has to decide whether upstream induced production might be reasonably foreseeable. So the standard is the reasonably foreseeable standard, and that is necessarily a fact-based determination. And the commission reasonably found here that it could not determine whether increased production might be reasonably foreseeable on the basis of this record, because again, we're talking about a 2-mile pipeline loop. And
I guess I apologize if I just missed it. Where did they say? You keep characterizing it as this is just a little 2-mile thing. There's not going to be any increase. I had read their decision as saying because you haven't shown us new wells would be dug.
Right. That is part of the analysis that the commission generally applies. That
another part of
it needs to know a source. But I'll say that in this case, it's a small project that's taking gas from other interstate pipelines. And as Your Honor was saying, the gas in these pipelines is fungible. There is record evidence that some of this pipeline gas might actually come from the Dawn Hub. That's at JA 66. And so whether it comes from the Dawn Hub or the Marcellus Shale, these are different sources. I mean, the Dawn Hub.
But I don't understand why if different sources, I'm not sure, since you just said they're fungible, it matters what the source is. The question is whether there's been an increase in production.
Right. But, well, I mean, the commission didn't know if there'd be an increase in wells drilled to supply this particular.
Again, why does there have to be a new well drilled if there's existing wells that are going to produce more? I did not understand. I'm just telling you, I really struggled with trying to understand why on earth the commission thought that was the relevant inquiry as opposed to whether there's going to be an increase in volume, and then they will assess whether it's sort of a material one with environmental impacts. But I didn't see them even doing that first thing of, is there going to be an increase in volume? They said, you haven't shown us that a new well is going to be dug.
I think it's more than just whether the well is going to be dug, Your Honor. If you look at JA 389, for example, that's in the certificate order. At paragraph 61, the commission is saying that a specific source of natural gas to be transported via this upgrade has not been identified with any precision and will likely change throughout the project's operation. And And,
think that's exactly
talks
my
about
concern. Right, that's exactly my concern. They're focused on the specific source of the gas having to be identified, and I don't understand. I think that's what I'm asking. That seems to me the wrong question. The question is whether there's going to be a change in the amount of production, whatever the source, the environmental, effects. There can be environmental effects, whatever the source.
I understand, Your Honor. I think that this is the standard the Commission usually applies, is that it needs to determine a source, and it needs to be concrete. I think that's the Commission's understanding in using this standard. But I will say, I don't think it.
Has any court decision said that's all that unless a specific source of gas is identified, then you don't have to analyze upstream effects? Is that how NEPA works? Is there any case that says that?
Your Honor, the Commission has been upheld before on its analysis of upstream impacts.
Specific source inquiry?
I'm not sure, Your Honor. I could find out and submit a letter if you would like that.
We have a case where we've said that there's no obligation to analyze upstream effects unless, in the gas context, the specific source can be identified. That would be of interest to me. I didn't find it, but I might have missed it.
I understand.
The fungibility of gas, it seems an odd inquiry to me.
Let me look into that, and we will submit that information to you. But I'll say that I don't think that we'll look into it, but that standard isn't determinative in this case. I mean, in this case, there's just no record evidence of induced additional production that could be reasonably foreseeable as a result of this particular pipeline.
Can I ask you about downstream effects?
Sure, Your Honor.
Let's talk about, you don't have enough information about end use. And if I read the record correctly, the day before it issued its environmental assessment, the Commission asked Tennessee Gas to provide more information about the intended uses.
Right, Your Honor.
And then it issued the environmental assessment without waiting for Tennessee Gas to respond, because they only asked the day before. So how can the Commission then reasonably say it lacked sufficient information about the end use if it waited until too late to ask Tennessee Gas for that information? Is that reasonable behavior by the Commission?
I think the Commission did, at least then, in that case, the Commission had the response before it in advance of the certificate order and the rehearing order being issued.
Even if already made the environmental assessment and said there's not going to be environmental consequence. We can't figure out. We haven't identified any material downstream consequence. It didn't look at the environmental assessment in the certificate order, did it?
No, I don't believe so. But it could have. It could have, Your Honor. And, any responses received before the certificate order issued, before the rehearing order issued, the Commission could have addressed any change that would be warranted by the response. But I think it's important in this regard to note that the Commission made the inquiry. It asked Tennessee about the ultimate end use. It wasn't just one data request. It was actually two data requests. Actually, Your Honor, there are two data requests, and I'm sorry, I'm not sure which one now that you're referring to, but there's one issued in December of 2018, and then there was the other one issued in May of 2019.
JA 175 to 77. It just struck me as quite unusual to see an agency ask for information that's critical to evaluating downstream effects the day before its environmental assessment and then not wait for a response before doing it. I don't think I've ever seen that before.
Well, I think, Your Honor, that was the second data request.
Was the data that they thought was relevant to evaluating downstream effects or not? I assume they asked because they thought it was relevant.
It probably was, but it may have been, it may have been additional information that came up as staff was preparing the environmental assessment, and if they
issued the assessment the next day.
Right, but they could have changed. They could have supplemented the assessment if the answer changed their minds about something. And that was the second data request. The first one was issued December of 2018.
Yeah, the first one he didn't get much response from Tennessee Gas. I think that's why he did the second one. What more do you need to assess the downstream effect here? right? You know there's going to be upgrade capacity. You know exactly what it is. You know the producer. You know exactly who the end users are, and you know that 97% of gas is combusted. What additional piece of information was needed and was missing to make an educated estimate of the downstream effect here?
Well, Your Honor, the Commission found that it didn't know the ultimate end users, the specific end users, because Columbia Gas is a local distribution company and it has different kinds of customers, has different classes of customers. Some may purchase gas from marketers rather than directly from the distribution company. You can make estimates.
I mean, it can't be that the downstream effects are only analyzed when you have, customer by customer individualized reports on usage. It was pretty clear in the Sabal Trail case that educated estimates are done here, and it seems to me there's not going to be many cases that you're going to have this sort of close set of how much is coming out and how much increased capacity is coming, and we know exactly where it's going.
Right, Your Honor. I mean, of course, the agency can make educated estimates, and it does. But in this particular case, petitioners did not ask the Commission to make specific estimates on the hearing, and the argument was not raised with specificity to the agency, and specificity is required.
Doesn't the agency have to make, at some point, kind of do its own job and say, if it says we can't, if it said we can't analyze downstream effects on this record, and they said, yes, you can, that disputes before us, and they have to have a reasonable explanation for why they couldn't do it. And to say that, well, there could always be more information doesn't seem to me responsive to the question of whether you could have made an educated estimate on this record, this existing record.
Well, Your Honor, the Commission it can make estimates, but I guess on this particular record...
An educated estimate here?
But I think the agency decided that here it wouldn't be meaningful to make estimates, or that perhaps it wouldn't be a truly educated estimate because of the specific facts of the case. So we have this local distribution company that's subscribing to this project for replacement capacity, and we have people transitioning from oil heat to gas heat. There are specific facts in this case that make it appear that an estimate would not be meaningful.
Why? First of all, the answer earlier was that this really isn't about people transitioning from oil to gas. If they are, that'll be a small amount. So that can certainly be addressed through mathematics and the adjustment. And if you know you're going to have increased capacity, you know where it's going, you know it's going to be burned, be used for residential and customer usage. Again, we're looking for educated estimates here. We're not looking for pinpoint precision.
Right, Your Honor. I think the record isn't showing that there may not be increased consumption here because we're replacing a certain amount of capacity with another, the same amount of capacity, just more reliable capacity. And that's just in the record. And the Commission decided that it wouldn't have been meaningful to make an estimate in this particular case.
Can I just ask, in the petition for rehearing, the following sentence appears. It's a J of 468. FERC cannot ignore the fact that adding firm transportation capacity is likely to spur demand for natural gas, and for that reason, the Commission must at least examine the effects that an expansion of pipeline capacity might have on consumption and production. But doesn't that flag the necessary question? Because I thought part of your response was that the Commission wasn't put on notice in the petition for rehearing of the need to look into this, and it seems like that's what's being asked here.
Right, Your Honor. I think it's a generalized argument. That particular argument doesn't, for example, ask the Commission to do a full burn estimate. I mean, that's a generalized argument that it doesn't engage with the facts of what the Commission was doing in terms of the data requests. The data requests are not mentioned in the rehearing request. And the Commission's conclusions based on the data request was not challenged on rehearing. So that's where, if the commission had been alerted with specificity that its interpretation of these data requests was being challenged, then the commission could have addressed it more specifically in the rehearing order. But we didn't have that opportunity because it wasn't raised on rehearing, not specifically.
Can I ask you, with regard to downstream effects, why do you even need to know the end users? And I assume, as a matter of science, there's just some equation which tells you that when you burn a cubic foot of natural gas, you're going to get a certain amount of carbon dioxide or whatever. And that won't change depending on whether the person burning the gas is an individual home for heat or a power plant or whatever. So what does it matter who's burning the gas as long as you know how much gas is going through the pipeline and the overwhelming majority of it will in fact be burned?
Well, Your Honor, I think it depends on the facts of each case. There may be the broad general estimate that 97% of gas that is transported is consumed, but some gas isn't consumed. I mean, local distribution companies sometimes release excess capacity. There are cases where the gas is not consumed, and so I think the Commission's view is that it needs more information about the burning of the gas, at least the Commission's view as reflected in this order.
What else would you do with the gas other than burn it? Does it have any other use?
Not that I'm aware, Your Honor, apart from selling it. I mean, I guess one could resell it if you're a marketer or a local distribution company. I mean, that would be the other use that I can think of.
Does FERC dispute that 97% statistic?
Not that I'm aware of, Your Honor. I don't know that it was addressed in the order itself. I don't think the order itself addresses the 97% statistic, at least not the majority order.
FERC is the expert agency here. I should think they would know the statistic, and so they could just discount any number by 3% if they felt they needed to. That would seem to be part of an educated estimate.
That is possible, Your Honor. I don't think that it was necessary to do that on the record of this case, but that's possible, Your Honor.
Because why wasn't it necessary?
Well, I think in the record of this case, because we're talking about a project where there are specific findings that the project itself would have minimal emissions and minimal environmental impacts. And
the finding of minimal environmental impact is after they said we can't figure anything out, so that seems less helpful.
Well, that was based on direct emissions from the project.
Can I ask one other thing, and that is, what's the status of this project? Are they, I'm talking about the 261 upgrade here. Is it completed? Is it already providing in service? Is it still, and there was a construction order. Is the construction still underway?
Yes, Your Honor. I believe counsel for the pipeline will also have additional information, but my understanding is that the pipeline loop is complete and in service, and the compressor station upgrades have been delayed because of the pandemic. But I believe that that's in process.
Okay, so this new compressor system is not up and operating.
I think so, yes.
Okay, unless my colleagues have further questions for you, we'll hear from Intervenors Counsel. Thank you, Ms. Hsu.
Thank you,
Mr. O'Neill. Mr. O'Neill, you're muted.
Thank you, Your Honor. May it please the Court, I'm Brian O'Neill. I appear on behalf of the intervener, Tennessee Gas Pipeline Company. We filed a joint brief with the other intervener, in this case, Columbia Gas. And to respond to the questions that have come up, first of all, the status of the projects, Ms. Chu got it spot on. the 261 looping, the 2 miles of looping is complete. However, the compression station upgrade has been delayed primarily because of pandemic-related issues. I begin by saying this. First of all, this is a reliability project.
Oh, I apologize. Can I ask one more just fact question?
Sure.
That is the Long Meadow meter station. Is that completed?
That is not completed.
Okay.
Will be completed later this year. Once again, it was delayed because of the situation.
Sure. I apologize. Go ahead.
That's all right. This is a reliability project, and we can't lose sight of that. It's a relatively minor project from Tennessee's perspective, but it's a critical one for Columbia Gas. It's a replacement capacity issue with them. While it's new capacity, certainly off of the Tennessee system, it's replacing capacity on the Columbia Gas system that they have been using, secondary point capacity, which is interruptible. The new capacity is firm. They can rely upon it year-round and don't have to have any concern about it being interrupted. In addition, they are replacing antiquated propane peaking capacity, which is not as useful and operationally it's not as good, and it is more costly. With respect to your reference of the statement at JA 113, Judge Millett, that is a statement that was made by the Massachusetts Department of Public Utilities. The statement in the record on behalf of Columbia Gas is at JA 87, and it's quite clear that the overwhelming majority of this capacity is necessary to replace the capacity that I just described, the unreliable, interruptible capacity.
To have firm capacity, it has to absolutely be there when they need it.
That's correct.
Is there going to be any increased capacity or not? Any increased capacity moving through this pipeline?
To the extent that there's no increase in as I understand, no increase in the demand or even in supply, as far as we know from Columbia Gas's perspective. However, there may be the ability to reconnect or to have additional connections where there are customers who are switching from fuel oil. So the way we view it from the standpoint of greenhouse gas emissions, that it's either a wash or it's a benefit. There's no detriment here from the standpoint of emissions. Finally, I'd point out...
My question wasn't about emissions. My question was simply increased volume of gas moving through this project. And you had before. Are you able to move and expected to move more gas? I don't know how you can have a firm, reliable, can meet a firm commitment. Ensuring you have it there.
That's correct. As I said, this is additional capacity from Tennessee's perspective, but from Columbia Gas's perspective, it's replacing unreliable capacity. Mm-hmm. So in that regard, from Columbia Gas's perspective, it's a wash, at least from the standpoint of their gas needs.
Mm-hmm. From Tennessee Gas, it's an increase.
Pardon me?
From Tennessee Gas perspective, it's an increase in the volume.
It is indeed. No, and Tennessee Gas is happy to have the business. Also, very quickly, Counsel for Petitioners referred to a pamphlet as at JA 296 as being an indication that there is increased demand here. If you take a look at that pamphlet, you'll see that the reference that Counsel is referring to has to do with something called the alternate backfeed project to serve a different market, the Northampton market, and that project has not gone forward.
Okay. Thank you, Mr. O'Neill. Let me make sure my colleagues don't have additional questions for you. Mr. Carlesco, we'll give you your 2 minutes for rebuttal.
Thank you, Your Honor. First, I would like to address the increased capacity. Commissioner Glick acknowledged that this contract increases about 40,000 decatherms a day over prior agreements with Columbia Gas. Moreover, Tennessee and FERC make the argument that because this is replacing oil heating within the area, that they can somehow disregard this. But this court directly admonished the commission for that same position in Burkhead at page 591. They said that if downstream greenhouse gas emissions are otherwise an indirect effect, the possibility that a project's overall emissions calculation will offset somewhere else does not excuse the commission from failing to do estimates in the first place, and that's exactly what we're seeing here. Additionally, I would like to touch on the commission's argument that this is solely a reliability increase. It is a reliability increase in that it increases the amount of gas that can come into the area. The issue with their reliability is that the pipeline capacity is constricted, so they increase the capacity so they can get more gas flowing through there. Moreover, interveners acknowledge as much, not interveners, Amicus American Gas Association acknowledges that this is very much an if you build it, they will come approach. And Food and Water Watch addressed that at Joint Appendix 462. They say that gas distribution companies will employ detailed long-term supply agreements that meet reasonably expected future demand. This is very much meant to anticipate additional growth. They also state that this is a prerequisite for increased gas expansion through their distribution network. So this is very much seen as an addition of capacity. Moreover, we ask this court to vacate this order because we see this as analogous to a recent order in Standing Rock Sea Tribe versus Army Corps of Engineers, in that this is an inadequate NEPA review of a pipeline with glaring deficiencies that would lack the disruptive consequences, and vacatur would address the seriousness of the order's deficiencies. And this is the standard that the court employs in Allied Signal v. NRC, a DC Circuit case from 1993. With that, I request that you vacate the order, and thank you for your time.
Thank you, counsel. Thank you to all counsel. We'll take this case under submission.
This honorable court is now adjourned until Tuesday, February 16th at 9:30 p.m.
Goodbye.